Good afternoon, guys. Aaron Dorr here at the Illinois Firearms Association. It is day 2 of what should be a 5-day bench trial here in East St. Louis over the unconstitutional, tyrannical assault weapons ban that took effect here in Illinois about a year and a half ago. We've been live on the ground all day here in court. We're out right now for a lunch break, and I had to go a couple blocks away because, to be very honest, downtown East St. Louis is not a place that anybody wants to be. It's not a very safe place. But guys, everyone kind of knows where things stand right now, but if you don't, here's the brief recap. This law was enacted early last year, 2023. There was 4 or 5 or 6 different lawsuits brought against it in federal court. Our organization is on these as amici in various cases. As you guys probably know, the case was initially heard by federal judge McGlynn, and he granted an injunction that barred the enforcement of this assault weapons so-called ban. That was appealed to the circuit court in Chicago, and the 7th Circuit issued what is perhaps the worst opinion that we have ever seen in any circuit when it comes to the Second Amendment. They actually believe, and they actually said, this is not really a gun rights issue because the AR-15 and the 150 other similar firearms mentioned in the law are not protected by the Second Amendment. And so this case then was, as you guys all remember, we appealed to the Supreme Court and asked them to intervene on our behalf. At that point, the Supreme Court said it is not a case they're going to take yet because the merits of the case have not actually been argued. In other words, we were asking for a preliminary injunction to block the enforcement of the law immediately. And what the Supreme Court said is that we will be interested in this case, but it first has to be argued on its merits. That is happening right now, today, and this week here in East St. Louis. Now, Judge Stephen McGlynn is a Trump-appointed federal judge put on the federal bench in 2020. He is the judge, again, who gave the preliminary injunction way back when. So right now, we believe, if his ideology holds, the law sure hasn't changed, the Constitution sure hasn't changed. So if he remains a pro-gun judge that he has been so far, then possible outcomes of this could be that he says, yes, this entire law is BS, it's unconstitutional, it's not enforceable here in Illinois. If he does that, and I would say it's likely that he does, he might stay his own order. In other words, he might say, it's not enforceable, but I'm going to put a pause on that order pending further litigation. Or he could say, basically, screw it, it's not enforceable, at which point Illinois will certainly appeal to the circuit court process, and they'll ask the 7th Circuit in Chicago to block the judge's decision. And if they make that appeal, they will almost certainly get it. So it's kind of a good news, bad news situation. The good news in all of this is that we have got to jump through these procedural hurdles to be able to appeal this case to the United States Supreme Court. I know it turns very slowly. It's been a very, very long year and a half for gun owners here in Illinois, but we are in the bench trial phase right now. We got 3 days left of the bench trial after today, and then we're going to have to wait and see what happens. Today, what we heard all day was testimony from James, I'm trying to pronounce his name here, James Ronikin, who spent his entire career working for Remington Firearms Company as a design engineer, and he spent the entire morning so far just blistering the idea that an AR-15 or any one of the 150 similar firearms mentioned in this law are assault weapons. He made it very obvious as a trigger design engineer, in particular, the difference between what it takes to fire an AR-15 as a semi-automatic rifle versus an M4 on full auto. It's been a great day so far of that kind of very methodical, very engineering-heavy testimony coming from, again, James Ronikin. But the idea here is to prove the absurdity of the idea of Pritzker's claim that AR-15s are assault weapons. We all know they're not. Everyone knows they're not. But we have to get through this process to continue with the appeal. So thank you to all of our members who have made all of our efforts here possible, for helping to fund our amicus briefs, helping to fund our appeals to the Supreme Court. We'll give you more updates throughout the week. But there's a lot going on right now here in East St. Louis. And again, whatever happens here, win or lose, this case will be appealed. And from there, it can finally be appealed to the United States Supreme Court. Guys, get involved today at joinilfa.com and go to our Facebook page for more information. Take care and have a great day.